Hello, everyone. Thanks for tuning in. We're going to get started in just a couple minutes with our estate planning presentation. We have about 30 folks so far and many still joining. Thanks for being with us tonight. Looking forward to hopefully a nice educational workshop tonight. So we'll be with you in just another minute or two and we'll get started. All right, we're going to get ready to get started. It's a few minutes past the hour. I am your host for today. Before I jump into the full introduction, if you can hear me, could you please type in the chat box and just say yes or hi or hello or hola, whatever language you prefer. Loud and clear. Thank you so much. Um, well, good to see everybody. My name is Terry Parham, one of the founders of Innovative Wealth Building. Good evening, everybody. I used to do this check where I'd ask people, hey, what color are my teeth if you can see me? And too many times I got yellow in the chat box. So now I just say hello, say hi, say where you're from. So thank you everybody for taking the time to tune in today. As I mentioned, I'm one of the co-founders of Innovative Wealth Building. Currently, I'm not living in the Southern Maryland area, but when we started the company 4 years ago, I was right there in our first building with the yellow walls, and we've come a long way since then. So, part of our commitment is just continuing to provide education. So, we thank you all for coming. This seems to be a pretty popular topic, and today we really look forward to getting into some things and just talking about the importance of estate planning and some planning considerations that might be helpful for you and your family. A quick disclaimer. Innovative Wealth Building has the ability to serve folks across the whole country, even internationally in some ways. However, although I have lots of education, I am not a lawyer. This is not legal advice. In fact, these are not recommendations for you personally. I'd suggest you talk to your advisor or your other trusted advisors for personal recommendations and financial advice. But this is meant to be educational and also to be generic in a sense that we won't talk specifically about anyone in particular. We will talk about concepts that may or may not be pertinent for your situation. So there's our legal disclaimer. Don't take this as advice. It's meant to be educational. And again, for your particular situation, talk to your advisor or an appropriate professional about your specifics. The meeting agenda for today is pretty robust. We're going to talk about why estate planning matters. We'll talk about what estate planning is, We'll talk about common tools such as wills, trusts, power of attorneys, healthcare directives, pitfalls, tools for success. We won't talk a ton about estate taxes. The tax portion is completely separate than just the planning portion. If you do have some questions about that, I can give some information. But today is really to focus on the topic and the strategies more so than the tax implications. Because for most of us, estate taxes aren't an issue at a federal level unless you have north of, let's just call it $25 million net worth. But if you're in a situation where your net worth is in the tens of millions of dollars, depending on the state you live in, certainly do want to consult with a professional because there could be some significant tax savings by doing estate planning correctly. You'll see me trying to keep an eye on the waiting room. I made the silly decision of not just letting everyone in automatically. So if anyone texts you or calls you and says, "Hey, Terry didn't let me in," just tell me in the chat box and I'll make sure that I keep admitting folks. So without further ado, we'll jump right in. As usual, if you're part of this webinar, you may already know, but I love questions. If you have any questions, feel free to type them in the chat box and we can learn and chat and correspond together tonight. So let's hop right in. What is estate planning and what does it cover? The overall concept is while you're living, you have control of your assets. And when retirement's over, or if we die prematurely, we want to have some guidelines on how our assets get distributed to the people or the organizations we care about. Now, if we don't make these decisions, our state or the federal government will make these decisions for us. The default plan is not always the right plan or the preferred plan. So we would much rather you get a say in what happens to your assets if you're no longer here. Additionally, things happen in life where we can't speak for ourselves even if we're living. So that's where certain tools such as power of attorney are important even during life. Another part of estate planning is if something happens to you, who takes care of the kids? This is important with young kids, but also if you have children with special needs, this can be a really important topic. Lastly, estate planning gives you the ability to manage your legacy. I sometimes say that estate planning is the difference between people using four-letter words when they talk about you when you're gone, or people telling great stories about how prepared you were and how planful you were and smiling the whole way through as they remember you. So truly, estate planning is how you ensure that your assets are in good order both while you're living and also when you're no longer here. So it's the ultimate way to either create a legacy or to leave a legacy in an orderly fashion that other folks are, able to appreciate and remember for maybe generations to come. Why is estate planning important? There's a ton of reasons. It avoids problems such as legal disputes or family disputes. It gives peace of mind. It protects your assets. It ensures your wishes are met. And it can simplify or eliminate the probate process. So in estate planning world, probate is that four-letter word that nobody likes. We'll talk in a moment about what probate is, but the worst case scenario that I've seen is someone passes away and then fighting takes place over items, over assets, over liabilities, over family members. We want to make sure we're prepared to live forever and that we're also prepared if unfortunately we're hit by the fruit truck tomorrow. So if we can take care of those two barbells, both long edges, then the rest in the middle should be copacetic. It should be pretty good. So again, while we don't want to dwell on the bad things, we know bad things happen. So estate planning allows us to get ahead of the curve and to set things up in the best fashion that we can. So we have a few stats for tonight. One of the stats is that 71% of Americans do not have a living will. Probably not a surprise that most people don't have estate planning documents in place. Now, of the folks who do have estate planning documents in place, most of the documents are out of date. Often, I ask people, when's the last time you updated your documents? The answer is typically 10 or 20 or 30 or 40 years ago. So that's one of the jokes that I hear sometimes. Well, last time we did our estate plan, our daughter was supposed to go live with Aunt Sally, but now their daughter's 40 years old, and she probably doesn't need to live with Aunt Sally. So that's one of the ways we know that an update to the estate plan might be needed. Oh, by the way, in our society, things keep changing. Tax laws are changing, estate planning laws are changing. If you had an estate plan done 5 or 10 years ago, some of the tools and strategies put in place may not exist anymore. As an example, there was something called the stretch IRA provision, where someone receiving a retirement account as an inheritance could take that retirement account and stretch it out and take payments over the rest of their life. To some degree, that has gone away, and now people have a much shorter time frame where they have to take out all the money, depending on the situation. So again, rules change over time. Most people could benefit from updating their estate plan, and for some folks, it would make all the difference in the world. So I mentioned this thing called probate. I'll give the audience a second to chime in if you'd like. Does anyone know a quick, easy way to explain what probate is? So if we have anyone in the crowd who knows and you want to share, let's just type in the chat box what probate is, and then we'll talk about what it is, why it's maybe not so fun, and then I'll even give you a short list of some of the states where probate or dying intestate is the worst. Okay, so Kathy said courts decide. Okay, so definitely courts are involved. Probate is a legal process where if your wishes aren't stated, the court and the state do get a say in what happens to your assets. Any other thoughts on probate? It's like that game you play at Thanksgiving where you like pull the little cards. When you hear probate, is there any word that comes to mind? Reporting's done by executor. Yeah, being executor can be a lot of work. That can be a part-time or a full-time job sometimes. It can be drawn out 100%. Um, so probate in the most basic sense is when someone passes away, the courts need to figure out all of their stuff, so all of the assets, all of the money, all of the cars, the I said cars, I was about to say vehicles, the house. Probate is a process of identifying everything you have an ownership in, identifying all of the debts, and then settling the debts and giving the assets to the people that are left over. So there's a question, do I need an attorney for probate? No, not necessarily. You can handle the probate system on your own, or just an individual can do some. Now, there can be probate fees, and we'll talk about that, and there can be lawyer fees. So probate can get expensive depending on where you live and the amount of things going through probate. Generally speaking, you want to avoid probate. It's going to be costly, it's going to be time intensive, it's kind of going to suck. So I had a client once, he was an only child. His mother passed away. She left everything to him, but it still took him a year plus to get access to a bank account that was supposed to go to him. But he had to go through this whole probate process, which is avoidable, and we'll talk about how to avoid some of that today. Um, PITA. Jeff and Shelby, could you spell that out for us? What does PITA stand for? Is it pain in the assets? Because if so, that is 100% accurate. Probate is something that you, I thought so. It is a situation you don't want to go through. Bar Joe says if multiple people entitled to assets, everyone needs to agree before you can do anything related to the money. Yeah, there's fighting that can happen. When a estate is probated and they say, "Hey, this person left behind all these things," you could have people coming out of the woodwork saying, "Hey, Terry said that that was mine," and then someone else says, "No, Terry said that that was mine," and the fight can go and go and go, and it could take a long time. Hey, Sharon. I know I was just keeping you secret. I almost made a motorcycle comment earlier, which would have been just for you. Thanks for being here tonight. So yeah, PITA, it's a pain in the assets. We don't want to go to probate. So we'll talk about how do we avoid probate. Now, I went to ChatGPT and I said, hey, what are the things that make probate bad? And I think it's some of the things you've already listed. It's long and cumbersome. There's high fees. There's strict formalities. Sometimes it's unfavorable when you follow the state rules around intestacy, which is basically dying without a will. There's taxes and fees and delays, and it can just be a complete pain in the butt. Now, there are several lists out there that say what states are bad for probate, what states are bad for dying without a will. I just pulled a quick list, and this isn't to be mean to any of these states, but this is what ChatGPT says. And many of our clients are in Maryland, some are in Hawaii, some are in New York, you know. So if you don't live in any of these states, you probably know some people that do. So just a heads up, according to ChatGPT, these are some of the bad states. So again, we want to avoid probate and dying intestate. Um, Sharon said it took 7 years to probate and settle everything, which is crazy. And if, let's say, all of your assets are in probate and your beneficiaries need them to live off of or to support your children, that's a bad situation. So, yeah, you want to try to avoid probate if you can. And sometimes things happen, you know. One of my best friends, his mom passed really early, really randomly, and no one saw it coming. So that's why we try to plan for forever, but then also plan for, if our story gets cut short tomorrow, how do we move things to avoid some of these terrible things that do happen administratively? So let's talk about wills. Now, wills are the foundation of estate planning. I would say it's level 101. That said, having a will can be a good thing, but if a will is all you have, maybe we're not fully taking care of things to the best of our ability. Wills are great because to some degree, you can name beneficiaries, you can name your executor, basically who's in charge when you pass. You can name a backup executor. You can outline guardians for the children. You can say, hey, my Range Rover, my 1970 Range Rover, I want to leave that to Bob. You can give your funeral wishes, the type of ceremony, have a big party, don't have a big party. The will gives you the ability to state your wishes. Now, the thing about a will, it doesn't sometimes carry the full authority of like, you have to do this. In some ways, a will is a suggestion, but it does have a lot of these valuable pieces. Now, on the topic of beneficiaries, let's say you have a 401k, and in your 401k, you go online to Fidelity and you say, Bob is my beneficiary. But then let's say when you create your will, you say, Jen is my beneficiary. So which place wins out? If you die and you leave behind your 401k, does the beneficiary go based off of the 401k or does it go to the person based off of the will? Does anybody know how that works? So what takes precedence? The beneficiary on the account or what the will says? Yeah, Kathy's right. The beneficiary. This can lead to issues, especially if you have an old 401k from 20 years ago or 30 years ago, and you never got around to updating the beneficiaries. So later we'll talk about maintenance, how to review these things and just make sure they're up to date. But an account payable on death or a beneficiary goes around probate, it circumvents the will. That's the best way to pass certain money to certain people. So again, we want to avoid probate. Use those beneficiaries on your bank account, on your 401k, on your IRA, on your investment account. Yeah, use the beneficiaries. Most accounts you can attach a beneficiary so we avoid probate. So yeah, great job. Let's talk about trust. Now, one spoiler alert is that trust are not just for rich people. Trust are more expensive than wills. It's kind of like, let's just say a hamburger versus a steak. They're kind of both beef, right? Maybe. But generally, the perception is a steak costs more. It's kind of like that with trust and wills. They're kind of similar, but they're very different. Wills are typically useful only when you pass away. A trust, That can be useful while you're living or when you pass away. So, a living trust or a revocable living trust is when you're living. A testamentary trust is a trust that's created at death, last will, and testament. So, again, the trust, you can use it while you're living and when you pass. What's unique is a revocable trust. If you're the one that puts the assets into the trust, you have control. You can continue to shift things, you can change the rules, you can change the beneficiaries, you can use the money yourself. Revocable, you have all control. If you choose an irrevocable trust, you're essentially taking your assets, gifting them, and then you're giving up control for the most part. So, long story short, most people probably only need a revocable living trust. If you have so much money that you'll never spend it, think tens of millions of dollars, then maybe irrevocable trust should be a part of your estate plan. Absent that, maybe not a great idea unless you really want to be safe and protect assets from creditors and other things. So again, to land the plane, there's several types of trust. Overall, trusts give you a lot more control than a will. It can be useful for blended families. It can be useful for protecting assets from your children's spouses if you want or need to. It can help you avoid probate. And trust are private. So I didn't say this about a will, but a will is a public document. People can see everything, they can look it up. A trust, only the people who are named beneficiaries are able to access the information that's relevant to their claim. So, again, if you want privacy, the trust is probably the way to go. If you want more control, again, the trust is probably the way to go. In most situations, side by side, a trust is going to accomplish the job likely more efficiently and effectively than a will. The downside is it typically costs more money. That's the biggest downside. So, how does a trust give more control than a will? Let's say that you're leaving money to your children. And let's say your child is 20 years old. I just talked to a client about this the other day. If you leave $500,000 to a 20-year-old, it could be spent in half a week, maybe less. But if you leave $500,000 to your child via a trust, and you stipulate in the trust the child can only take $10,000 per year until they reach age 40, in which they then have access to the total balance of the trust, it gives you control. Within the trust, you could also say who's in charge, what the rules are for distributions. You can list education, health, etc. In a will, you can't really do that because a will's not designed to give you control after death. A trust, you really can put the people in place, the guardrails in place, the rules in place. You can even set up for the assets to be managed in perpetuity forever on behalf of the people you care about. Whereas with a will, that's not going to happen. You might just say, "Hey, Bob, you get the money. See you later. Hey, honey, thanks for the money." So trusts are more complex, but they do give you a lot more control and flexibility. Whereas wills are typically statutory documents. It's basically a template for the most part. Fill in the template, click the button, and you're done. Yeah, you can add some addendums and things of that nature, but again, it's not going to give you some of the control and the guardrails and the people that you can appoint that a trust would. Great question. And later I'll get to the slide, but I'll basically just say it now. Terry's not saying don't have a will, but I am saying a will and a trust generally gives the best outcome because you're covering all your bases and you're using all of the tools to the best of their ability. So that's how I was one slide ahead. This is where I usually would say that. But again, to recap, wills are something we use at death. Trust can be used during our life and at death. Wills go through probate. A trust can avoid probate or drastically simplify it by avoiding probate for a lot of items, such as your house. You can put your house in trust versus letting it go through probate or another means. Um, Trusts are private, wills are public record. Again, wills are more affordable because they cost less, and trust are more complex and cost more. Says, does a trust cost more because a lawyer is managing it? Yes and no. You can set up a trust, and then once it's set up, you don't have to pay for management. The cost difference is just at creation. So, big picture prices to get a will could cost you anywhere from $0 to, let's just say, $1,000. A basic will is probably in the $0 to $1,000 range. If you want a basic trust, you're probably looking more like $3,000 to $10,000. Depends on the estate planner, depends on the state, their expertise. Trust can be tens of thousands if you're getting into super complex things, but it's that simple. A will is generally, free. In some states, they have the documents online to maybe $1,000. And then the trust typically will start at 3,000, maybe more, depending on the situation. But that's just it. One is more work. So a lawyer would typically charge more to have it done. You can self-service. There are tools like TurboTax for wills and trusts and things of that nature, but it all just comes down to, if you want to pay an attorney or if you're comfortable using self-service tools. Could a will and trust have differing distributions? What supersedes what? Typically, the trust would supersede the will. So if the beneficiary of something is a trust, but it's also stated in the will, then it's going to go to the trust. So typically, if you're going to use both tools, you would want to coordinate so you're not double naming things. So yeah, ideally, they're going to do two separate jobs. You'll have them side by side, but we want to have the will do as little as possible and then have the trust do most of the heavy lifting. Again, depending on where you live, the fees doing a will-based plan with the probate and everything, it could be tens of thousands of dollars, whereas the trust costs you more upfront, but could save you tens of thousands of dollars or more in just lawyer costs, probate fees, time delay, 7 years, like Sharon said, etc. Great question. Let's talk now about power of attorney. Um, Power of attorney basically gives someone else the ability to act on your behalf. The most popular powers of attorney are financial, where someone can enter into contracts on your behalf, or healthcare. Real life example, if you're in a car accident and you are incapacitated, a healthcare power of attorney would give your person who you've appointed, say it's your sister or brother, the ability to come into the hospital, get all of the data about your situation, and then to make decisions on your behalf. If you have outlined that you don't want to be resuscitated, they can refer to that document and they can make that decision. If you say, hey, use every medical means to keep me alive, again, they look at the document and that's what they say. Um, so, great question. Medical power of attorney gives you the ability to make decisions. An advanced medical directive, that kind of outlines your wishes. So they are two different things. The power of attorney gives you the ability to act. The advanced medical directive is like the playbook. So the medical directive is like what I want to happen, and then the power of attorney gives that person the ability to act on your wishes. Absent the medical directive, you could still appoint someone to make decisions, but if you haven't given them a playbook, results may vary. So again, that's why it's important to have all these things, because if you give them the ability but no guidance, you may get the wrong result. Great question. They go in tandem. Last thing about power of attorney, there's something called a durable power of attorney where you just give someone the power and they can kind of use it whenever they want. Most of us, especially people like me with trust issues, we don't like those ones. We want the springing power of attorney. That's the power of attorney where if Terry is incapacitated, then X person can step in and make these decisions. So, in most cases, I see people create springing power of attorneys where there's some type of event that occurs and then it elevates that person to having the power to act. Again, probably a good idea to have a person named and then a person as a backup. And then if you want, you could have a backup to the backup because, you never know. Maybe the hospital can't get a hold of them. Maybe they're out of the country. Maybe it was a common accident. So that person's no longer able to act on your behalf. So yeah, these are just the backup plans for the backup plans. But overall, that's what a power of attorney does. It gives someone the ability to speak and act on your behalf when you're not able to do so for yourself. Man, I should have just had you guys ask the questions for the whole time. These are really good questions. So, like I said, you're ahead of the curve. Advanced directive states your wishes, it avoids conflicts, and it can include a living will component. There's all sorts of different takes on this. Some states have something called like the five wishes, and there's just these different things where you basically state what you'd like, what you don't like, what you want, what you don't want. And by having the directive or the playbook, it makes it easier for someone to carry out your wishes without feeling guilty. It takes away some of the fighting. Bob says, no, we need to do this. Paul says, no, we need to do this. Their spouses say the other thing. It could get really rough and ugly. So, we can make it easier for the people that we leave behind or that we leave in limbo by taking the time to script out the playbook and then putting it in a place where they can access it. So again, great question. The Advanced Healthcare Directive and the Power of Attorney, they kind of go hand in hand. Let's talk about guardianship. And this is specifically of children. Again, think of either minors or a child with special needs that could be an adult or any age. We said earlier that most people don't have a will or estate plan. Of the people with estate plans, less than 1 out of 5 have a trust. Again, trust costs more money. People typically don't want things that cost more money unless they really see the value. Of the people who've done this nice level of planning, only 6% have nominated guardians for their children. So to me, that begs the question, if you don't nominate who's going to be the guardian of your child, what happens? And I know this from firsthand experience. Does anybody know if you don't write down who gets your children, if you're no longer able to care for them, what happens? I'll wait a minute and see if anybody knows. Hopefully, no one's been through it personally. I think my next slide gives it away. So I'm going to quickly look and see if it's on the next slide. Okay. Grandparents or siblings, kids, aunt or uncle? Yeah, possibly. Word of the state? Yeah, state. Yeah, you guys are on it. So, oh, darn it, I'm 2 slides ahead. So I'll just get to the punchline. So here's the punchline. In most states, if both parents pass away or are unable to care for the child, a court will step in and decide who raises them. If you haven't named a guardian, the court may get to pick, and it could be a family member or it could be a stranger. That's a terrible situation. Could be a stranger, could be an orphanage, could be a family member that you really don't want to raise your kids. So the bottom line is it's up to you. It's either your plan or the default plan, which may not be a good choice. My wife and I, we went round and round on this topic because we really struggled to think about if we both unfortunately passed away, who we think would be best to step in and help raise the kids. And I think we finally, I say I think, because we literally just relocated, so we're updating our documents as we speak. So as of our last conversation, we have agreed on the primary and then the backup. But this was a tug of war, and it's a tough conversation. So I would just encourage you that if you struggle to think about this and to agree with your spouse, that's normal. It's a really hard thing to think about, but I would just encourage you to really try to formally notate that because you don't want the state or an orphanage or someone that you really don't want to raise your kids to end up being the person to raise your kids. Again, this could lead to lots of family fighting and other things. So it's such a super important thing to make sure that you do plan for guardianship, especially with young ones. So I'll go back to my one slide that I kind of jumped ahead of. And I think we've already kind of talked about this. The point of guardianship planning is just to decide who will care for your minor child. You can have your primary guardian, you can have your backup guardian, and it's tough because you want this person to kind of be a proxy of you, or you want them to give your child the best thing that is possible. And that could be from an educational perspective, a behavioral, a social, an economic. There's so many ways, emotional. I mean, again, it's a tough thing. So that's why my wife and I it was like a merry-go-round trying to talk through this and figure out the best circumstance for a terrible scenario. So just wanted to encourage you that if you are working through this or you need to work through this, that it's a tough conversation, but if you do it in love, you'll get to the other side of it and you'll have a much better outcome than the alternative. So let's talk a little bit about some common pitfalls. Probably not surprising. The number one mistake is not having a plan. You know, failure to create a plan is planning to fail. Number two is not updating the plan. I am not joking when I say 90 to 95% of the conversations I have about estate planning, the next sentence is, man, we really need to do that, or man, we really need to update that. So this is your sign to update it. Last is just not evolving your estate plan over time. That could be as simple as adjusting for the inherited IRA provisions changing. It could be how trusts are managed changing. It could be you moving from California to Florida. The way trusts operate in California is different than how they operate in Florida. Certain states have weird loopholes where trusts can kind of operate in perpetuity, whereas in other states they can't. So the world changes, your assets change. You just want to make sure that you review your plan periodically to ensure that you're not missing anything. So Tammy said many years ago, my ex-spouse and I couldn't agree on this, and I wanted my sister to have control of the kids and money. He wanted my sister, but his brother to have control. It was tough. Years later, I agreed. Yeah, it is so tough because in addition to physical custody and guardianship, kids will also get Social Security benefits that are coming in. There's going to be college decisions. There could be life insurance. There's so much that goes into it. So we're fortunate that we work in finance. We are surrounded by other financial advisors, so that helps us feel a little bit more comfortable. But yeah, it's a tough thing. So, thank you for sharing that, Tammy. I know it's a really hard thing because, again, before my wife and I had kids, we did our first estate plan and it was like, oh, easy, easy. This is not hard. There was only one thing that was surprising for us. But then after having one child, two childs, multiple homes, other stuff, then we're like, okay, this is a little bit tougher, and we have to actually force ourselves to sit down and have the conversation. So here's a few suggestions for keeping your plan current. I would just suggest that every few years at least that you review your plan. It doesn't have to be every year. Every year would be phenomenal. But if you said every 3 to 5 years that you review and update your plan, that would be awesome. You don't have to shoulder this alone. Put it on your advisor's plate. Say, hey, advisor, can you put a note in my file that in 3 years we need to update our estate plan? Give them permission. That's what I do sometimes. I ask clients, hey, by what date do you want to have this done? And then we'll try to work to that date. Sometime it gets pushed. Sometime, we reorganize our priorities. But if you can do this every 3 to 5 years, you're going to be in pretty good shape. Additionally, major life changes are a good time to review and update your plan. Getting married, having a child, having grandchildren, retirement, divorce, these are all important times to go back and review. A spouse passing away, unfortunately, that probably completely disrupts the plan you already had for estate planning. Now you have to go back and change your primary beneficiary and now your contingent beneficiaries or the people you hadn't named at all, now they come up to primaries and there's all this other stuff you have to think about. So, yeah, major life events, it's tough, but when you're able to, that's a good time to update your plan. The last part is to communicate with your loved ones. So I'll just put this out to the crowd if anybody wants to share. Has anyone had success with creating their estate plan and then sharing some of it with the people that are in the estate plan. That could be parents sharing some of the ideas with the kids. It could be a person sharing it with their sibling. Just curious if anyone's had success not only creating the plan, but then communicating enough to kind of give the commander's intent to the next generation. So Deborah said my mother's will is about 5 years old. She's now 96 and has slight dementia. Can she update her will? Whew. Thank you for that question. I gave the woof because yes, she can update her will. It gets a little tricky if there's dementia or what some would consider diminished capacity or just confusion and things of that nature, because this goes back to a will or certain things can be argued. Someone could say, hey, mom had dementia and when you had her update that, and I don't think that's what she wanted. So then it could get a little bit messy. So I would say it is better to go ahead and update it, but just know that depending on how severe some of those things are, one, the estate planner could have some hesitation, but two, if there's a contentious situation with family, you might want to think about that on the front end just to make sure that there's no big issues. Often our clients will put in language such as if someone contests this will or these documents, then they're cut out. We don't want any fighting. So if you have something bad to say, just like go away and your piece will go to someone else. So unfortunately, we have seen those things happen. There was a comment that my mom's estate was to sell her property to me, so all of her assets are not in her name, and I'm joined on her bank account. Um, yeah, I've seen that where people are joined on bank accounts, they're joined on investment accounts, they're joined on houses. What I would say is sometimes it's not good tax-wise to be listed on a bank account or to be listed on a house or something like that. There are some tax reasons why you may not want to be listed because, again, depending on the amount of net worth or how big the asset is, there could be tens or hundreds of thousands of dollars of gain by not being listed. But again, that's a common thing that, parents want to have someone listed on there or a trusted person who's on that account. Um, so, yeah, well, thanks everyone for sharing. These are tough topics to talk about to the next generation, to either go upstream with the conversation or downstream with the conversation. But if there is a soft way you can open it up, it's good. When I was in my early 20s, I became a financial advisor and I sat my parents down and we had the talk. And the talk was basically if I, have something happen to me, you guys are in charge. And even at that point, because of life insurance and investments, there's over $1 million that would be going to somebody. If I didn't tell my parents, maybe they wouldn't have assumed anything. And then all that money would have been sitting at some insurance company, or the state would eventually say, well, it's unclaimed property, let us take it. So at a minimum, that's why I communicated it with my parents even in my early 20s, because I said, hey, worst case scenario, I want you guys to know so that you can get the money and my sisters will get the money and my nieces and all that. So yeah, the communication part it's tough, but it's super important. All right, so we have some checklist items. These are maybe an oversimplification, but to just think about what you currently have in place. Do you have a will? Do you have a trust? When's the last time they were updated? Do you currently have a power of attorney? Again, if you're incapacitated, have you listed someone to handle your financial affairs, make healthcare decisions, etc.? Healthcare directive. Have you stated your wishes? What do you want for your care? What do you not want for your care? How much money to be spent to save me is too much money. Like you can outline that. Do you have a guardianship designation for your children? You know, your all of your investment accounts. We have a cool tool called Asset Map that puts all of your assets on one sheet of paper. When's the last time you've audited every single account to make sure TSP, 401k, IRA, taxable investment account, even your bank account, you can put a beneficiary on there so it avoids probate. After you've updated your estate planning documents, Have you shared a copy with your advisor? We can put it in your file, and we can even list your trusted contact where if something happens to you. Have you stored them somewhere securely at your house? Is it a fire box, or do you have printed copies somewhere? You don't have to share all the details, but the person who's next in line should at least have a card or someone to call to get that information. And we just want to make sure that we have your advisor or other attorney or other professional advisors on file. It's a great thing for us as advisors to know your estate planner, your accountant, your elder law attorney. Like if you have any of those, want to know who they are so that we can be in a position to help. So, Diane, thank you so much. I'm glad you found some good information tonight, and absolutely make that call and keep putting those steps in place to make your estate plan as strong as possible. So just a few of the things that are easy checklist items to review and think through. And we have some other assets as well to help with estate planning. So if you need or want any, just let us know um, in the chat or via email, and then we'll be able to share even more of this stuff with you. Again, estate planning is a big, important topic, but it's hard to like actually do the work and to see it through. Believe me, there's been plenty of starts and stops with me personally on this. So how can IWB assist? I am not an estate planner, but hopefully through this conversation, you've seen that people like me do have the ability to give you some insight that's hopefully helpful on the topic of estate planning. Your advisor can help coordinate and help you think through some of these big picture things. And then if you go the self-service route, or you'd like us to introduce you to someone locally in your area, or to help you interview an advisor that you talk to on the phone or something else, just let us know. We're here to help. And we do like to help introduce and work with those other professional advisors to make sure that you're taken care of as well as possible. So I'll quickly touch on your action plan. It's one to gather all of your documents, all the estate planning things. And a good starting point is just your balance sheet. If you make a sheet of all of your assets, house, car, bank account, investments, Bitcoin account, if you have Bitcoin, retirement accounts, everything else, start with your assets and then let's audit who the beneficiaries are. Next, review your beneficiaries. I got to stop talking ahead of my bullet points. Talk with your advisor. And then, again, this is a hard part, but at some point, open up a soft conversation with family to the right people so that they know what's coming. One of our clients, they're leaving behind probably a lot of money to their kids. One of their kids is a doctor, one of their kids works at a church as a pastor. They're in very different tax situations. So they're strategically leaving different amounts of assets with different tax statuses to the different kids. So they want their kids to know that even if you don't get the same amount of money, we've thought about that in advance based off of taxes to try to make it as equitable as possible. So again, communication can help head off any potential misunderstandings down the road. Before we close up, we have this QR code, and this is for your feedback. If you have found value in our conversations, our webinars, or you've just enjoyed working with your advisor and working on your personal financial journey, we'd love it if you did leave us a review because probably 99% of our clients are from personal introduction. But by also having a bit of a presence online, we can help other people we otherwise may never meet. So I think this QR code works if you do want to scan it. Let me check it because, we have technical issues once a year. Hopefully today's not the day. Yeah, I think that works. Cool. So again, no pressure, but if you want to, I figured I'd put that on the slide if anyone does want to share any feedback. And then as we get ready to close up, I tend to finish how I start, which is to say thank you for being here. And we have a little bit of time left. So if there's any questions, I will be standing by to answer some. So everyone who said thank you again for coming and glad to hear that you took away some valuable nuggets from our conversation. Um, Susan, thank you. Ed, thank you. Yeah, I can absolutely share the slides. So if anyone does want the slides, let me just give you an email address, your team at teamiwb.com. If you just say, hey, send me those estate planning slides, we'll send them to you. Unfortunately, I don't have slide notes because I just make it up as I go. But happy to send you the slides. And then if you have any other questions, please let us know. So, yeah, unless there's any other questions, again, thank you all so much for being here with us today. This was obviously an important topic to a lot of people. So we appreciate you taking the time to spend your night with us today. And if you have any questions, let us know and we'll be here to support. So I do see a question in the pop-up here. It says, my dad is 80 years old with a will. I was thinking about putting his house in my name to go under my trust, or should he get his own trust? Great question. Short answer is probably his own trust. His house qualifies for something called step up in basis, which is basically a tax-free transfer to the next generation. If the house is in your name, there's no step up in basis or it could be reduced. So tax-wise, you typically don't want it in your name. You want to receive it at death. So you get a step up in basis and avoid all of the income taxation. Great question. Do you have to file taxes on a trust? It depends. Some trusts that have current year income, yes, they will have to file taxes. Some trusts won't have to file taxes. Trust tax rates are worse than personal income tax rates. So generally, you don't want to have a trust earning a lot of current year income because the tax rates are terrible. So yes, both can pay taxes, but you don't want to have taxes in your trust if you can help it. Great question. What about putting adult children on the deed? That works the same way. If you put them on the deed, they may not get the step up in basis at death. So then that doesn't give the full tax benefit where if they're not on the deed. Instead, you could put the children on as a beneficiary or like a transfer on death. That varies a bit from county to county, state to state. But there are alternatives to putting the kids directly on the deed. In certain scenarios, there are certain types of trust where you can transfer the house to your kids. There's some nice tax and estate planning savings, but you only want to do that if your income or your net worth is, again, tens of millions of dollars, at least 10 million plus. So, great question. If you have specific questions, definitely turn that one to your advisor. But generally, putting kids on the deed doesn't really give you the optimal result. Should revocable trust be beneficiary of all your assets? Good question. Generally, if you want an easy life, the trust can be the beneficiary for everything as the primary. However, there are slight differences with retirement accounts where maybe you do want to name people directly instead of the trust. Retirement accounts are the main asset where it's at least worth a conversation. So the default is, yep, the trust is good, but think about your retirement accounts. Think about the age difference between you and your beneficiaries because it might make sense to name the person directly versus the trust. Great question. All right. Well, thank you, thank you, thank you. I hope I did a decent job of, acting like I know a little bit about estate planning without hopefully pretending to be a lawyer because I have a master's. I didn't go to law school. But again, thanks everybody for tuning in. Hope you have a great night, and we'll look forward to seeing you next time.